in Southeast Asia, and good morning, our speakers and colleagues from Europe and Uruguay. We would like to welcome you to the regional workshop on the Hague Agreement, which is organized by ARISE+IPR project. My name is Yung, and I am the moderator for the meeting today. So as you all know, we originally planned to have this workshop to be taking place physically in Hanoi today and tomorrow. However, due to the COVID-19 situation, we had to transform this regional workshop into a virtual one via Zoom platform. So even though we do not have chance to enjoy quite hot weather in Hanoi at the moment, as well like hang out with each other for nice coffee and tea break, but I'm sure at least we are safe and we will have all the new and exciting experience today and tomorrow via this Zoom platform. Before we start our meeting, I would like to inform on the participant that the meeting is being recorded. So if you do not wish to be recorded, you can choose to leave the meeting. In case you choose to continue with the meeting, please note that your data will be processed according to the Zoom privacy statement. This recording will be circulated among our ASEAN member states for internal use and training purpose. During the last 2 years, I think our design exam minors colleagues had chance to meet each other for many occasions under ARISE+IPR activities. But this is the first time that we meet each other via this virtual platform. And we have to say that we are very happy and honored to have the representative from all 10 ASEAN member states. I guess some of you already know each other, but I would like to give everyone a chance to say hello and also a way to check if your audio and video work fine. So now we will do a little check-in. So I will call your country, and if all the members of your country can turn on your video, and one of your member from your country on behalf of the whole team can introduce the team and say hello to everyone. So we will do a little check-in. So let's say 10 seconds per country. How about we start first with Brunei? Hello, colleagues from Brunei.
Hello. Hi.
Hi. Good afternoon.
Can you introduce yourself to the whole audience?
Hello. Hi. I'm Amelie from BRIPO.
Yes.
And I'm Adi. Very long name, so just call me Adi.
Yes. Yes. Thank you, Ami and Adi, for joining us for the workshop today. Yes. Thank you. Now we move to Cambodia. Hello, our colleagues from Cambodia. Mr. Bin, are you here yet? I think maybe it's difficult to fly from Brunei to Cambodia. So now we will fly from Brunei to Indonesia. So we come back to Cambodia later. Hello, our colleagues from DGIP Indonesia.
Hello. Hello, everyone.
Hello.
Hi. Hi, Mr. Eko. Yes.
Yeah, I am Eko from Indonesia, DGIP.
Yes. Very nice to meet you. Yes.
Yes, nice to meet you.
Colleagues from DGIP.
Yes.
Yes.
It's Mr. Sahdi Hadianto and Mr. Anton Edward Wardana.
Yes. Ah, okay. Yes. Thank you for joining us today. Yes.
Yes.
Thank you. And now we move to our colleagues from Laos, Pedia.
Good afternoon.
I think we can come back, we can fly back to Laos, Pedia again. Now we will travel to Malaysia. Hello, our colleagues from MyIPO.
Hello, hi everyone. I'm Dia from MIPO, and together with two colleagues from MIPO as well, Mr. Muhammad, he is from a legal division, and Ms. Fazila from industrial design division.
Yes, thank you, dear, and thank you, Mr. Mohammed. Welcome to the workshop today. I think we have the connection from Laos. Good afternoon, Ms. Katmani.
Good afternoon. Can you hear me?
Yes. Can you speak a little bit louder because we couldn't hear you clearly?
I think my mic doesn't work.
Ah, yes.
Can you hear me?
Yes, I can hear you.
Oh.
Yes. Yes.
Good afternoon.
Good
My
afternoon.
name is Katmani from the IP Laos.
Yes. So from Laos, we will have two colleagues, Ms. Kemani and Ms. Suchita.
Yes. Unfortunately, one of my colleagues, he's not available the whole week.
Ah, okay. Yes.
Maybe I will inform you later via email.
Yes. But we're happy that we had two colleagues from Laos joining us today. Yes, thank you. Yes. We will move next to our colleagues from Myanmar.
Hello, good afternoon, everyone, and good morning from the speakers from the Spanish and the Uruguay, right?
Yes.
My name is Tidiamo. I'm the design section from the Department of Intellectual Property. We will join three participants, my boss, Momo, and my colleagues, Jokai. But my boss is right now, he has another meeting in the other place, so she will join soon. Thank you so much.
Thank you, Director Ki. We got very good connection from Myanmar. Thank you. Yes. Now we will move to Singapore. Good afternoon, Ms. Lee.
Hi, everyone. Yeah, it's nice meeting you all from via Zoom today. Yeah, it's great to see some familiar faces as well. So hope we can get to learn more from the sharing sessions today. Yeah.
Yes. Okay. Thank you, Ms. Lee. Yes. And now our colleagues from Iberville.
Hello.
Yeah.
Hello, everyone.
Yes. Hello, Emily.
Yes. Good afternoon. We are three participants from ITO Phil. We have two examiners with me, Ronald Sapanta and Eldrian Ramos.
Yes. Thank you, Amelita. Welcome, Iberville colleagues.
Thank you.
And now we fly to Thailand. Good afternoon.
Good afternoon, everyone.
Yes.
I'm design examiner from Thailand.
Yes.
I'm very happy to join this section today. I hope that I could get any further knowledge, new information from everyone.
Yes. Thank you, Kun Pani. So from Thailand,
yes.
Only one representative, or
we have three participants.
Yes. You are working in the office now, right? Not working
Yes.
from. Okay.
Yes. I have today to come to the office to work. So
Yes.
the rest of the week I am working from home.
Yes. Okay. Yes, thank you. Good afternoon, Kun Orion. How are you doing?
Hello. Good afternoon.
Yes.
Okay.
Is it 1 meter from each other? Like, do you keep the social distance?
Okay.
No, I'm kidding. I can see both of you in the video. Yes.
Yes. Good afternoon.
Yes.
Yes. I'm Juthamon Lupngam from DAP Thailand. I'm a legal officer from Legal Affairs Office. Yes, and I'm happy to meet and join you guys here today.
Yes.
Thank you.
Thank you for joining us. Yes. And now, last but not least, our colleagues from Vietnam.
Hello everyone.
Yes.
We are from Vietnam.
Yes. Can I know how many participants from
Yeah,
Vietnam?
there are 3 participants from Vietnam,
Yes.
including me. My name is Nguyễn Quang Tuấn from the Industrial Design Examination Center. Also, we have Mr. Dương Việt Anh from the Industrial Design Examination Center and Ms. Trần Nguyệt Minh from the Legislation and Policy Division from
Yes.
IP Vietnam.
Yes. Thank you, Mr. Tuấn, and welcome on Vietnamese colleagues to the workshop today. And last but not least, sorry, our dear colleagues from ASEAN Secretariat. Good afternoon.
Hello, good afternoon.
Yes. Good afternoon, Mr. Lloyd. Yes.
Hello, hi.
How many participants from ASEC joining the meeting today?
We have, including myself, 4. We have Senior Officer Maslina Malik.
Yes.
Then we have Technical Officer Ika Hashim.
Hello.
And Technical Officer Fibrian Pramuda.
Yes. Okay. Yes. Good afternoon, ASEC colleagues. Thank you.
Good afternoon.
Yes.
Thank you for the invitation.
Yes. From ARISE+IPR, we also very honored to have with us today Mr. Tiago, project leader from ARISE+IPR, and Ms. Carolina Ditach, the deputy project leader. Also, the whole team based in Bangkok and Alicante, also joining us in the workshop today. We are also very honored to have with us today our distinguished speakers. May I introduce to you Mr. Ernesto Rubio, ARISE+IPR external expert, joining us today from Uruguay. I think it's very early morning now in Uruguay, 5 a.m. in the morning. Good morning, Ernesto.
Good morning, Jung. Good morning, everybody. It's really a pleasure to be with you.
Sorry, Ernesto, you on mute. Yes.
Now you're listening? Yeah.
Yes, we can hear you now.
I was saying that that it is a pleasure for me to be with you today.
Yes.
And it is true, it's quite early here in the morning. It's 5 o'clock in the morning in Montevideo. And but it is really a pleasure to start the day in your company.
Yes. Thank you, Ernesto.
Look forward.
Yes. We hope that you managed to get yourself a cup of coffee to start the workshop
Yes,
today.
I did. A cup of tea to start with.
Yes, thank you, Ernesto. We also have with us today Mr. Stefan Hang, the design expert from EU IPO, joining us from Alicante, Spain.
Yeah, good afternoon, everybody, and good morning, Ernesto, to Uruguay. Indeed, it's a pleasure to meeting you all, and I have my cup of coffee here already. I'm looking forward to this event and to the discussions which will unfold later on. Thank you.
Yes, okay. Thank you, Stefan. We have on the representative from the ASEAN IP office, as well as our dear colleagues from ASEAN Secretariat and our speakers. In order to keep a good memory of our event today, I would like to invite everyone for a group photo. So if everyone could have to turn on your video. Yes. So we will do a group photo. Yes. So now I will say 1, 2, 3, and everyone will smile as big as you can. So 1, 2, 3. Yes, maybe one more to be sure. So 1, 2, 3. Yes. Okay. Our photographer said that we need one more. So let's try to smile big again. So 1, 2, 3. Yes, Thank you, everyone. Yes. Before we start our workshop today, I would like to invite Mr. Lloyd Tech Kong, Head of Competitions, Consumer Protection, and IPR Division from ASEAN Secretariat, to have a few words to open the workshop today.
Thank you very much, Yung Lee. ARISE+IPR, Tiago, Ms. Caroline Pritach, Mata Fontana, Tong Lee, Marisa Lassa, and other ARISE+ representatives, ASEAN Member States, IP leads and delegates, fellow colleagues, IP experts, distinguished experts, Mr. Ernesto Rubio and Mr. Stephen Hain. Thank you very much, ARISE+IPR, for organizing Activity 11, Regional Workshop on the Hague Agreement for Design Examiners from ASEAN IP Offices. The workshop is timely as it will focus on the implementation of the agreement at the level of national office. And we are truly honored and delighted to have the presence of two of the most distinguished and well-known design IP experts, which we can tap on for this workshop. Mr. Ernesto Rubio, ARISE+IPR external expert from Montevideo, Uruguay, and Mr. Stephen Hain, design expert, EU IPO, Spain. This activity supports Initiative 5.1 of the ASEAN IPR Action Plan 2016 to 2025 on accession to inter alia the Hague Agreement by those AMS that have yet to accede to the Hague Agreement. To date, we have Brunei, Cambodia, Singapore, Vietnam, and Vietnam just recently acceded, which have acceded to the Hague Agreement. Indonesia, Laos, PDR, Malaysia, Philippines, and Thailand are in varying steps in the progress with the eventual aim of acceding to the same. In this regard, we note the regional workshop will focus on the Hague system and the role of the IPO office as the office of a contracting party. And we will also be tutored on the EU and the implementation of the Hague system in the EU at the national level. There will also be experience sharing in the implementation of the Hague system from IPOS and Brunei IPO, and on accession sharing to the Hague system from IP Vietnam and DIP Thailand. We will also be educated on the preparatory work for accession to the Hague Agreement, legal and other considerations. The workshop will end with a roundtable discussion on the request from AMS on ARISE+IPR support to the Hague Agreement and design-related activities in general. With that, I wish you all a fruitful and meaningful two-day online workshop, which I believe you'll find very useful and could apply the knowledge gained for your respective countries. Thank you very much indeed. Thank you.
Thank you, Mr. Lloyd, for your opening speech. Next, we would like to invite Ms. Carolina Bitach, Deputy Project Leader of ARISE+IPR, to have a few words to open our workshop.
Thank you, Jung. Dear Mr. Lloyd, dear ASEC colleagues, and dear designs colleagues from ASEAN IP offices, I would like to welcome all of you to this regional workshop on the Hague Agreement. The Hague system, actually for international registration of industrial designs, provide a practical business solution for registering up to 100 designs in 64 contracting parties through filing one single international application. The recent WIPO report shows that the number of applications filed under the Hague system grew by 3.7% in 2018, reaching more than 5,400 applications. The ARISE+IPR has provided technical assistance to ASEAN member states for the pre-accession and also the post-accession implementation of the Hague Agreement. For example, we have organized post-accession training for designs examiners in Cambodia in August 2018, and also we joined DIP Cambodia for an awareness raising campaign to promote the Hague system among local communities in March 2019. Under this activity, ARISE+ is also providing technical assistance to the pre-accession to the Hague Agreement by creating a gap analysis for some ASEAN member states planning to accede, meaning Indonesia, Laos PDR, Malaysia, and Myanmar. The regional workshop today is another effort of ARISE+IPR project to enhance the capacity of ASEAN design examiners to implement the Hague Agreement by focusing on preparatory work for accession and promoting the sharing experience between design officials for countries that they are already part. I thank you all for your participation, and I wish you a fruitful workshop today. Thank you.
Thank you very much, Carolina, for your opening speech. Yes. Before we start our workshop today, I would like to introduce a bit our agenda today. So for today, we will hear 4 presentations. We start first with the general introduction about the Hague system and role of IP office at the office of a contracting party. After that, we will have 3 presentations with sharing experience about the implementation of the Hague Agreement, 1 in European Union, 1 in Singapore, and 1 in Brunei. The presentation have been shared with you in advance, so the speakers will highlight the key points from their respective presentations. In case you have any questions, please choose the raise hand features, or you can send your questions to the chat box to the host EU-IPR or ARISE+IPR. So after each presentation, we will leave time for 1 or 2 questions right after each presentation. The rest of the questions will be addressed during the Q&A section at the end of the workshop today. So now we would like to invite Mr. Ernesto Rubio with the presentation on the Hague system and role of IP office at the office of a contracting party. Mr. Ernesto Rubio is an international expert on intellectual property with extensive experience in WIPO administered treaties. For almost 30 years, Mr. Rubio held different positions of high responsibility within WIPO. He was Assistant Director General and Senior Director for Trademarks, Industrial Designs, and Geographical Indications. He supervised the work of the Madrid system for international registration of marks, the Hague system for the international registration of industrial designs, and the Lisbon system for the international protection and registration of appellation of origins. So now we would like to give the floor to Mr. Ernesto.
Thank you, Jung. Thank you so much. Let me start sharing screens with you. Okay. So, can you see my screen now?
Yes, we can see. Yes.
Good.
If you have a little bit louder, then I think it's okay. Yes.
Louder?
Yes.
Yes.
Ernesto. Yes.
Is that okay? Good.
Yes.
Very good.
Thank you. Yes.
Well, as you said, well, we will start with a general introduction about the Hague system. And prior to this meeting, I circulated a first version of this presentation. Now I'm going to introduce to you a shorter version because we do not have too much time. But in any case, I will be available for questions on the whole presentation. So to start with, I will follow this outline that's indicated here. First, a brief reference to the Geneva Act of the Hague System and its membership and how it works. And then followed by an introduction of the roles that your office shall play as the office of origin of an application and as the office of a designated contracting party. As you know, the Geneva Act is one of the treaties governing the Hague system for the international registration of industrial designs. And it has at present 64 members, including 62 states and 2 intergovernmental organizations. Here is the list of Geneva Act members as of June of this year. And as you may see, the intergovernmental organizations that are party to this treaty are the European Union and the African Intellectual Property Organization. And among the member states, there are at present 4 ASEAN countries, as Mr. Lui was recalling: Brunei Darussalam, Cambodia, Singapore, and Vietnam. And here is the current geographical coverage of the Geneva Act. 89 countries that are either direct members of the Geneva Act or at least members of one of the 2 intergovernmental organizations that are members of the Act. As you may recall, the Hague system, very much like the Madrid system, can only be used by someone who has an attachment to a contracting party. And in the case of the Hague system, this attachment can be an industrial or commercial establishment, nationality or domicile, or habitual residence, which is more flexible than just domicile in one contracting party. That's attachment with one contracting party is necessary in order to be able to use the system, for any person to use the system. But unlike Madrid, in the case of the Hague system, there is no need for the applicant to have a basic design in the country of origin. An applicant can file directly an application without having, before filing that international application, a basic design in his country of origin. And another difference, quite important difference, is that under Hague, in principle, it is possible for an applicant to designate its own country for protection, something that is not possible under Madrid, where you need to have protection in your country of origin directly from your national office. The advantage of using the Hague system, instead of following the traditional filing route country by country, is that the applicant needs to file only one single application instead of several different applications in different offices, in only one language instead of several languages. And it has to pay fees in one single currency instead of different currencies. And it will need a local representative only in limited cases. So it is eventually much less expensive and less cumbersome as well to follow the Hague international route instead of several different routes and procedures to get protection for designs in various countries. Now, in addition to the advantages of central filing, the holder of an international registration also enjoys the benefits of what is called central management. And this means that he can renew his international registration every 5 years through a single request sent to WIPO with effect in all the designated country contracting parties of interest to him. And similarly, he can request that certain changes to his registration be recorded in the international register, also with effect in all the designated contracting parties where he so wants. So this is why the Hague system is becoming so popular. We will now see the role that your office should play with respect to industrial designs, international applications that are originating in your country. That is the role of your office as the office of the applicant's contracting party. In principle, there are 2 functions that should be considered. First of all, and most importantly, providing advice to national applicants wishing to protect their designs abroad by using the Hague system. And secondly, possibly also acting as a transmittal office. That is an office that receives an international application from a local applicant and sends it to the International Bureau of WIPO for processing. But as we will see this is an optional function. The advice to be given to national applicants concerns at least the following. First of all, providing advice on the advantages of using the Hague system, how to prepare an international application, how to deal with possible irregularities and with possible refusals in designated contracting parties, and finally, how to manage the international registration throughout the life of the registration as such. So you should be ready to inform your nationals about how to prepare the international application, that is, what is the mandatory content of the application, the optional content, and including the fact that with respect to certain contracting parties, there is some additional mandatory content, as we shall see. You will advise them also, for example, about the fact that an applicant under the Hague system can file up to 100 designs in a single application, but only if all those designs belong to the same class of the international classification for designs, the Locarno classification. It will be also important to provide advice to your nationals regarding the presentation of reproductions and how it will be convenient for them to consult the Hague Guide for users concerning how to present those reproductions. Regarding where to file the international application, this will depend on whether your country allows or not for applications to be filed through your office. If you do so allow, the applicant will have the option to file the application through your office or to do it directly at WIPO. And in fact, more than 95% of international applications today are filed directly at WIPO and not through a national office. If you decide to accept the filing of international applications through your office, what is called in the terminology of the Hague system indirect filing, well, you should be ready to receive those applications in one of the official languages, English, French, or Spanish, and in the appropriate form, the M1 form. And you will have to transmit that form to WIPO, preferably within 1 month, with an indication of the date when the application was received in your office. Your office may charge a transmittal fee and may also accept to collect other fees from the applicant and send them to WIPO, even though really very few offices do so. If the applicant decides to file his international application directly with WIPO, he will probably do it through electronic filing. And in fact, more than 99% of the applications received by WIPO today are received through electronic filing, the electronic filing interface that WIPO has on its website, which is very convenient and very user-friendly. So I will not get into further details now. Okay. Is there's some
yes.
Yeah. Okay.
Yes. Yes.
So I was saying that I will not get into further details now into how the international procedure follows now, just to make it shorter. But as you know, WIPO will receive the international application, will examine it from the point of view of formalities. And if everything is okay, it will record it, the international registration in the international register. It will publish it in the International Designs Bulletin, and it will notify it to all the designated contracting parties. So what we are not going to see now is what would be the role of your office if your country is designated in an international registration. First of all, you will find out that your country has been designated by having a look at the International Designs Bulletin. This is a bulletin that is published by WIPO every Friday on the WIPO website. So you can even download that information from the bulletin, arrange to have it downloaded automatically. And what is important to recall is that when you see that you have been designated, your country has been designated in an international registration, you will know that immediately from the very beginning, that international registration shall have the same effect in your country as a national industrial design application having been regularly filed with your office. And later on, we shall see that if it has not been refused, or if it had been accepted, it will have the same effect as an industrial design registered in your office. You will have in principle 6 months to examine the international registration and possibly refuse protection. Now, if your country allows for a position by third parties, you may have up to 12 months to do so. But a refusal of protection can only be based on certain grounds, in principle, substantive grounds that are envisaged in your law and that would apply to industrial designs that have been filed directly with your office. It may also be based on an opposition by a third party if your law so allows. No? If there are substantive grounds for refusal or an opposition, your office shall notify this refusal to WIPO within this prescribed period of 6 months or 12 months and provide all the information required for that purpose, and preferably in a form, a special form, that model form that WIPO makes available for that purpose. In this respect, communication with WIPO shall be either in English or in French or in Spanish, you may choose. And if the notification that you send, the refusal notification that you sent is irregular, WIPO will ask you to provide whether missing information is necessary. Now, if you refuse protection, the holder of the international registration will get that information from WIPO. He may then come to you and request you to review or to reconsider your decision, or he may appeal against that decision. It depends on what your law provides for in this respect. And what is clear is that he should enjoy the same rights and the same remedies as any applicant having filed an application for protection of a design directly with your office. Of course, if he has no address in your country, you may ask the applicant or the holder of the international registration to appoint a representative. And your office will eventually decide whether to confirm the refusal or to withdraw it. And if it decides to withdraw the refusal and to grant protection to the industrial design and in whole or in part, at least for some of the designs that are contained in the international registration, your office will then notify WIPO accordingly. Your office may also issue what is called a statement of grant of protection instead of a withdrawal of refusal. A statement of grant of protection, in fact, may be sent following a refusal or even in the absence of a refusal. And there are model forms as well to be filled in to notify such statements of grant of protection to WIPO. If WIPO receives from you a statement of grant of protection or a withdrawal of refusal, it will then record the international, this statement of grant of protection or withdrawal of refusal in the international register, and it will inform the public through the bulletin. And the international registration will then be protected in your country. The international registration that has not been refused shall enjoy in your country an initial period of protection of 5 years. But this may be renewed every 5 years and up to at least 15 years. If the law in your country happens to offer a longer term of protection for industrial designs registered at your office, for example, 25 years, then the international registration will also enjoy in your country a maximum duration of protection of 25 years. During the life of the international registration, all renewals and changes to the international registration will be recorded directly by WIPO and will have the same effect as if recorded in your office. In this respect, there is not much work for your office to do, except maybe regarding a change in ownership, a correction, or an invalidation. In the case of a change in ownership, whoever asks for such a change, may be the owner himself, or it may be the transferee in some cases, will file the relevant request directly with WIPO. WIPO will record the change in the international register to make it public against third parties. However, the validity of that change in each designated contracting party will depend on the law of each of them. For example, if your country requires some statement to be presented or some document to be presented for the change of ownership to be valid in your country, well, you may ask for such document to be submitted to your office, certifying the assignment, that the assignment has effectively been made. Now, concerning errors, if there is an error regarding an international registration, WIPO will make the necessary correction and will notify it to your office. Now, the effects of the correction will depend very much on the type of error. If it's a minor error, maybe there's no need to go through it again in much detail. But if it is an error that would mean that the international registration no longer qualifies for protection in your country, the international registration will go throughout the same procedure as if it had been that change or that correction in the international registration will go through the same procedure of a substantive examination and possibly refusal on the basis of substantive grounds as if it were a new international registration. Would be the procedure to be applied. Finally, regarding invalidation, an international registration will be subject to the same provisions and the same procedures for invalidation or revocation or cancellation as may be envisaged in your law with respect to a national registration. Simply that the holder of the international registration should in any case be afforded the opportunity to defend its rights in good time. If the invalidation procedure concludes with the invalidation of the right and there is no longer possibility to appeal that decision, then your office shall notify all those details to WIPO, and WIPO will take note of the invalidation in the international register and will publish a notice in the international bulletin whereby that international registration is no longer valid in your country. Well, with this, I conclude this first presentation. I hope it has been clear enough for you, and but I will be available for questions as Jung suggests. Thank you very much.
Thank you, Ernesto, for your very detailed and comprehensive presentations. We have received quite a number of questions for your presentation, but in terms of time, maybe I will show one questions that we just received from the participant.
I have to stop sharing.
Yes, if you could have to
okay,
stop sharing from your side.
I stopped sharing.
Thank you. Yes. So we have received one question regarding international application. Regarding international applications originating in ASEAN member states, what is your advice for a country to decide whether those applications shall be filed via the IP office in direct filing or filed directly at the IP of WIPO, direct filing? So what are the pros and cons?
Well, thank you very much for this question. That direct filing with your office will mean certainly some work to be done by your office. And in the case of the applicant, from the viewpoint of the applicant, there may be a little element of risk in the sense that the date of an international registration depends on the date when the application was filed. But this is if it has been filed directly with WIPO. If it has been filed with the Office of a Contracting Party, that date will be the date when it was filed, provided that the Contracting Party Office notifies this to WIPO within a month. If for whatever reason the international application does not reach WIPO within the month, the applicant would lose the filing date, and the filing date would be the date when it was received at WIPO. So there's a small element of risk. This used to be an important element of risk when applications were sent by post. Today, there's less risk in that respect because most offices of contracting parties to the Hague system today maintain electronic communication with WIPO, something that I would recommend. It's very important to do if your office, if your country joins the Hague system, that your office have this electronic communication. Now, if you allow the possibility of applications originating in your country to be filed through your office, in any case, the applicant will have the option in principle to do it through your office or directly with WIPO. And in fact, most applicants in most countries do choose filing the application directly with WIPO and do choose, as I said, mentioned earlier, using basically the electronic filing facility of WIPO. More than 95% are filed directly with WIPO or the international applications. More than 99% of those received by WIPO filed electronically. Now, why would your office accept taking care of receiving international applications? Well, maybe there are two reasons why you may wish to do so. First of all, if there are applicants in your country that do not have easy access to electronic filing and would submit the application on paper to your office, and then you would take care of transmitting it to WIPO. Another reason may be if you have applicants that are not so familiar with one of the working languages of the Hague system, that is English, French, or Spanish, and you might wish to help, the office might wish to help the applicant in completing the application in one of those languages. I don't know whether I have addressed correctly what you were expecting.
Yes. Thank you for your answer, Ernesto. I think for these questions, we can hear more input sharing from our ASEAN member states, like why they decided to go with indirect filing or direct filing. Because in terms of time, maybe we will address this question more during the Q&A section. So thank you very much for your answer, Ernesto.
please.
So next, we will move to the second presentation of today. I would like to invite Mr. Stefan Hang with the presentation on the EU and the implementation of the Hague system in the EU and at the national level. Prior to joining the EU IPO 13 years ago, Mr. Stefan Hang worked as an attorney as well as an IP in-house counsel in the automotive industries. At the EU IPO, Mr. Stefan Hang is currently a member of the legal service. Among others, he represents the EU IPO before the EU court in Luxembourg in trademark and design matters. Mr. Hang also works for the legal issues in relation to the EU IPO design practice and is practicing in the Hague Working Group for the EU. In case you have any questions, please send your questions to the host EU IPO ARISE+IPR. All your questions will be answered during the Q&A session. We have received some numbers of questions for Ernesto, and we hope that we will receive more questions. Please send more questions. Thank you. And now we would like to invite Mr. Stefan Hang. Mr. Stefan, the floor is yours now.
Yeah, thank you, Jung. I hope you can all hear me very clearly. I am going to share my screen with you. So give me 1 second, please. I hope you can see my screen now shared with you.
Yes.
Yeah, I see you nodding your head, Jung. So yeah, thank you very much again for the invitation to speak here at this very international workshop. As mentioned by Jung, I'm also a member of the Hague Working Group, and it's always a pleasure to exchange views and opinions on the different legal systems. Now, as to my presentation today, which I understand you have present as well, these are the topics I would like to cover. I have loads of slides in this presentation, and of course the 20 minutes will be insufficient to cover all of them, but I try to do my best to go through them, and of course I'm also available for questions afterwards. So my presentation will focus on how the international registration system designating the European Union functions from the perspective of the EU IPO. So in part it will also address the issues which were mentioned by Ernesto. Now, the European Union was not able to join the 1960 Hague Act, which was not accessible for intergovernmental organization, which was only enabled by the 1999 Geneva Act. And so the European Union became a member as of the 1st of January 2008. At the same time, the majority of EU member states are also Hague members, of course, most of them of the Geneva Act as well. But there are still 8 member states who have not joined the Hague Union yet. But of course, the citizens and the legal persons of those member states, they are also part of the European Union, and by that way, they are indeed part of the Hague family. Now, importantly, when we consider Europe as a geographical region, it is of course wider than the European Union member states. And you may know that we have 3 what we call EFTA states, Iceland, Liechtenstein, and Norway, which together with the European Union form the European Economic Area. So this is an integral part of the internal market, this European Economic Area where the goods and the services can move freely. Those 3 EFTA states being members of the Hague Union, this is a very convenient way, of course, when designating the European Union to designate them as well. And then also there are, of course, other countries in close proximity, Switzerland, of course, and now the United Kingdom following the exit from the European Union, but they recently also became a member of the Hague family, will be a prominent destination coupled with that of the European Union. Now, upon joining the Hague Union, the European Union declared that the EU-IPO cannot act as what UNESCO called a transmittal office. So the filings directly have to go to a WIPO. The European Union declared, in accordance with the duration of protection of EU designs, that the maximum shall be 25 years, also for international registrations designating the European Union. And the third declaration made by the European Union is that concerning the individual designation fee, which shall replace the designation fee. And the amount thereof was set by subsequent information notices, the latest being from September 2011, specifying that the application fee for the designation of the EU shall be 67 Swiss francs. I believe instead of the basic fee 42 Swiss francs, if I'm not mistaken. Okay, so we only have 3 declarations made on part of the European Union. But of course, EU member states, which are members of the Hague Union as well, they also made their own declaration, which is important to bear in mind if, apart from the European Union, an applicant may wish to designate a specific member state as well. For an example, I have looked up that, for instance, Estonia made a declaration on the unity of the design, which is required, the same as I understand is the case for Vietnam. So when considering the European Union and its member states, the declarations made upon joining Hague may depart. Now, in this next section, I would like to explain how the procedure at the EU-IPO works in dealing with international registrations. But in order for you to understand how it fits into our workflow, into our registration system, just allow me first of all to explain the very basics of the filing of a European Union design, so that you can compare it then with the international registration, how it fits into our workflow. So this is, these are the basics for the registered EU designs. The application, first of all, of course, as in most jurisdictions, or in all jurisdictions, I assume, is assessed as regards formalities. So if the fee has been paid, if the product indication is correct, and if the graphical representation adheres to the formal requirements. Now this formal examination goes hand in hand with the examination of the 2 only substantive grounds which are examined at application stage prior to the registration. And this is that, of course, what is filed has to comply with the definition of a design. And secondly, it shall not be contrary to public policy or morality. So these are the 2 only substantive grounds which are examined for direct registered EU designs. There is no assessment of other substantive requirements, and in particular, there is no assessment of novelty, or what we call individual character for the European Union. There are some member states who assess novelty, but the European Union does not do so. So this is a very, let's say, a speedy registration, and an application which has no errors usually is registered within 4 working days. And any other invalidity grounds, such as that the design is not novel, that there are earlier rights which are violated by the design, is only assessed at invalidity stage following the registration. So this is the system, the basics of the registered EU designs. And now I'm turning to the international registration designating the EU. In case of international registrations which are accepted straight through, where there is no error detected on part of the EU IPO in terms of the substantive grounds, goes as follows. So the European Union, not being a jurisdiction with ex officio novelty check, has in total 6 months from publication to carry out a substantive examination. In fact, this takes place within 1 week. And the substantive examination is limited to the 2 grounds, as I have mentioned it, which also apply for the registered community design. It has to comply with the definition and shall not be contrary to public policy on morality. And if that is all in accordance with that, the EU IPO just sends an email to the International Bureau with a statement of acceptance. Importantly, the European Union does not republish international designs, unlike other jurisdictions, and I believe Cambodia and Singapore are republishing, but the European Union does not do so. For this normal registration procedure, where the international registration is accepted, there is no need to appoint a representative with a location in the European Union. This may only be necessary in case a ground of refusal is raised or in case of a later invalidity action. So these are some slides just to show you the practicalities of how it is dealt with by our examiners. I will very briefly go through it. If you have more questions, of course, later on, I'm happy to explain it more in depth. So this is the weekly International Designs Bulletin, as you can see. And when the examiner includes the designated contracting party, EM, for the European Union, a list of the weekly publications is generated. And this allows also to result in an Excel sheet. And this is the Excel sheet examiners use to examine these 2 substantive grounds of examination. And if everything is in accordance with the European Union rules in this respect, 2 columns are added to this Excel sheet and then sent to the International Bureau as a statement of acceptance. I'm not sure whether this is really the best practice. This is up to date, but this is how it is still done at the EU IPO. But I have to mention that we are currently developing a new tool, an IT tool, where this examination is more integrated in our system. And so there may be some changes in the future also of how we communicate with the International Bureau. Now, let me explain to you how the procedure works in case a refusal is found. So when one of the substantive grounds does not allow the international registration to proceed with the designation of the European Union, the UIPO will communicate a reasoned notification of refusal to the Bureau, which then will forward it to the applicant. And then, as I have explained to you, for an applicant who is not located in the European Union or in one of the EFTA states, that applicant or holder must appoint a representative from the European Union so as to facilitate the communication. And that representative or the holder, as the case may be, has to respond within 2 months by submitting his or her observations on the refusal. And following the receipt of these observations, the UIPO will then finally decide whether it withdraws its objection or whether it finally rejects the international registration. Now, as I have mentioned, the European Union is a member since 2008, and we only have had so far a single refusal, which is only a provisional refusal yet, so it is not final. And here you can see the respective design, and you can see that this bottle contains a hand showing a middle finger, which is an obscene gesture in the European Union, or at least part thereof, and therefore this application was rejected on grounds of public policy and morality. The final decision again still has to be taken on this application, but this is the only one we have found so far which may fall full of substantive grounds of examination since 2008. Yeah, and then the third kind of procedure, which is following the international registration, this is the invalidity procedure. And as mentioned by Ernesto, it follows exactly the same rules as they apply for registered EU designs. So when a international registration designating the EU is challenged in invalidity proceedings at the EUIPO, the EUIPO will directly inform the holder or its representative of this application. And then the procedure runs as if it was a registered EU designs with the same timelines, etc. And only when the EUIPO declares the invalidity of the international registration, then of course the International Bureau will be informed of this final decision, so that the effect of the international registration is invalid as far as the European Union is concerned. Okay, so this will be, I suppose, my final section of my presentation. I just wanted to show you some statistics as they are usually asked when giving presentations on the Hague Systems. So these first three slides, they are very interesting indeed. They originate from the current evaluation of the design acquis in the European Union. So the European Commission is at the moment contemplating whether or not the design system should be revised for the European Union. And as part of this exercise last year, a public consultation took place with a number of questions on the various issues, but some also concerned international registrations. So this question number 42 raised was whether or not it proved a useful complement for the European Union to join the Hague system. And this is the result from the questionnaire, and you can see here, if you discount the last two rows for where there was no respondent made in the survey, or no opinion was given, if you only count the first four rows where an opinion was given, you can see that the vast majority of participants of the surveys considered the accession of the European Union to the Hague system to be either very useful, that was the majority, or just useful. Whereas a minority only responded that the accession was useless or completely useless, a minority of 2% in total. So this shows that from perspective at least of the users in the European Union, the accession is considered overwhelmingly positive. Now, as I have mentioned, there are also still some member states who are not members of the Hague system, and so the question here, number 53, was whether or not it would be considered useful that also these member states finally join the Hague Union. And as you can see here, again, there was a clear answer given that yes, that the participants in the survey saw the benefit of joining the Hague Union. And then we have here another slide, which is not directly related to the international registration system under Hague, but it is asking the question when applicants would like to file their designs in various jurisdictions, which often happens, what are the main difficulties in achieving the same protection? And you can see here that the top answer given in terms of the difficulties faced, that applicants complain about different requirements for design representations. So this goes hand in hand with what Ernesto has said, or being one of the main benefits, of course, of the international registration system, that all the entire formality examination is dealt with by the International Bureau in a uniform manner for all the jurisdictions. So it goes to show that the international registration system can alleviate many of these issues that applicants and holders face when trying to expand their filings. Yeah, this is a statistic for European Union design filings with the latest numbers. You can see that for 2019, the filings for international registrations in the bottom row, the first two rows, fast track and regular track, these concerns EU designs. So in the course of the last years, international registrations more or less amounted to 20% of all the filings. Last year, around 15,000 filings out of 110,000 designs with effect in the European Union. And this is just for your handout, the top 10 statistic for EU designs, and you can see if you compare it with the international registrations, it is very similar. So at this point, I would like to conclude. I have just spoken exactly almost 20 minutes, so I'm happy to receive any questions you may have.
Thank you, Stefan, for your presentations. I don't know how to say, but maybe we are very happy and lucky that we will have a very busy and dynamic Q&A sections, because I think the audience continue to send a lot of questions during your presentations.
Okay.
Due to the time limit, may I share with you two questions that we received. The first one from Azek. Are there any reasons why international applications cannot be filed through the EU? Administrative or operational reasons?
Well, as explained already by Ernesto, I believe that one of the principal advantages of allowing an indirect filing has to do with paper filings, no? So if you have an applicant or a holder, it may be more convenient to file it at your national office if you would like to submit your international design registration on paper to your national office, which then is responsible for transmitting it to Geneva. For the European Union, of course, it makes little sense as far as the member states are concerned. It would only be Spain, let's say, who would profit from this shortcut in the paper filing submittal. But for all the other member states, it doesn't really make a difference whether an applicant, for instance, from Denmark files by paper and sends it to Switzerland or to Spain. So for the European Union, at least, this aspect makes no sense to have admitted the EUIPO to transmit the applications. And of course, also as mentioned by Ernesto, this additional step may carry some risk for the applicant or the holder. So these were the reasons why for the European Union, at least, it was decided that the EUIPO does not act as a transmittal office. And in any event, 99% of filing are on E. So I would not expect that this will change in the future. I have mentioned that the European Union is currently evaluating its design acquis. And as far as the European Union system is concerned, it is in fact allowed to file an EU design via a national office. But we have seen that in the recent years, the numbers have considerably dropped. So we only receive a handful of registrations for EU designs from our national offices. So we will expect that in the future legal reform, also as far as the EU system is concerned, this will be abolished. So yes, it was both administrative and, let's say, operational reasons, on account of which the European Union does not give this opportunity.
Yes, okay. Thank you, Stefan, for your explanation. We also received one question from IPO Singapore. What is the volume of the invalidity actions triggered by EU IPO for international registered designs?
I have to unmute. My apologies. Yeah, as explained, the invalidity actions against international registrations, they follow exactly the same rules as for registered EU designs. As far as our total population of designs is concerned, registered EU designs and international designs designating the EU, per year, only 0.05% of designs are challenged in invalidity proceedings. So this amounts to roughly, last year we had 550 invalidity requests, 550 validity requests. And I have explained in my presentation that about 20% of our designs are international registrations. So if you do the math, I would estimate, we don't have a separate statistic for this, I would estimate that last year we had about 110 international designs designating the EU challenged in invalidity proceedings at the EU IPO. So just to give you an idea. But again, we don't have really, as far as invalidity is concerned, a statistic distinguishing that. So I would estimate that last year we had about 110 actions against national registrations. So I don't know if this is was more a statistical question or a question on the rules, but come back to me if I haven't really provided the appropriate answer.
Yes, okay. Thank you, Stefan. I also would like to thank you on the participant. On your questions have been well received, and on your questions will be answered during the Q&A session. We have received a lot of questions for Stefan and Ernesto. Thank you very much. So now we will move to the next point on our agenda. We will move to the section 3, the implementation of the Hague system in some ASEAN member states. The ASEAN Action Plan 2016 and 2025 set a goal to support the accession of all ASEAN member states to the Hague Agreement. Till now, out of 10 ASEAN member states, we have 4 member states who have become members of the Hague Union. We had Singapore became party to the Geneva Act in April 2005, Brunei in December 2013, Cambodia in February 2017, and very recently we had Vietnam in December 2019. So for this section, we will hear about the experience of Singapore and Brunei in the implementation of the Hague Agreement in these 2 countries. In case you have any questions, please send it to our host, EU IPO or ARISE+IPR. We will have all the questions addressed during the Q&A section. So now I would like to give the floor to our colleagues from Singapore, Ms. Lee. Ms. Lee, the floor is yours now.
Okay, let me share my slides. So to start off, perhaps just to give a background on sorry, when we acceded to the Hague Agreement. So as shared, we acceded to the Geneva Act 1999. Sorry, in April 2005, and this was because it was part of Singapore's obligation under the EU FTA. So. And next, we will go on to share some of our Hague filing statistics. So generally, there has been an increasing trend in the number of Hague applications that Singapore receives. So in general, in 2019, we received about 953 international applications, and these translates into 3,351 designs in international applications. And if you compare this to our national filings, which is about 1,400 in 2019, so the number of applications received through Hague is generally quite substantial. Then the top 5 filers in 2019 as listed in the slides, and we have noted that these filers who file through Hague generally do not file national applications with IPOS directly. So next, we will share on how the applicants can file an international application. So they have 2 choices. First is through WIPO, and the second is indirect filing through IPOS. And of course, as shared previously, the preferred mode is direct filing through WIPO, as they can conveniently file it through eHague. And for indirect filing through IPOS, they can only submit a paper form DM1, and they have to pay an additional transmittal fees to IPOS as well. And for the past years, we have never received indirect filings from applicants as well. So so all of our filings comes from WIPO directly. So for Singapore, we are under Hague designation fee number 1, so level 1. So the fees that we receive will follow the level 1 standard designation fees. And this table can be found from the WIPO's website, which lists down all the fees for the various designated countries. And next, we'll go through the general process of processing of an international application. So the applicant files an international application generally through WIPO, and then the formal examination will be done by IB. And after they publish the application in Hague Bulletin, the IPOS will receive the details electronically, and we will review the application and provide a response within 6 months. But in generally, we will give a response around a week or so. And so there are 2 actions that can be taken. It's either approval, which is for majority of the cases, or we can issue a notification of refusal to IB. So so far, the notification of refusals that we issue is in relation to Class 32 applications that we receive. This is because IPOS does not accept designs filed under Class 32, as they do not meet the definition of the design under the Singapore Registered Design Act. So for these applications, we will request the applicants to make amendments to the classifications, to the article name, and possibly also the images. And if they manage to rectify the issues, we will withdraw the notification of refusal and also inform IB as well. So next, this is how our officers view the international applications once we receive it once the WIPO publishes from the Hague Bulletin. So our system will check the data and create a task in our IP2SG system. So the details are the same as what is found on the bulletin. And as you can see, so our officers will actually they do not need to refer to any other WIPO's website or the bulletin to obtain the details, and they can process the tasks directly. So once the application has been approved, so this is how the IP2SG public platform looks like. So any person from the public can actually do a search of approved design international app registrations using our IP2SG website. So they can do a search using international registration number or via the publication date, or using the bulletin number, application's name, or Locarno classification. And perhaps just to share, Singapore has recently acceded to the Locarno agreement in March this year. So basically, we adhere to the Locarno classification, except with the exception of class 32. So this is an example of a search based on a bulletin number. So if you click onto one of the registration number, you can see the details. And from here, you can tell that the IR status for Singapore is approved. Yeah, so that's all for today. Today's sharing from us.
Thank you, Ms. Lee, for your presentations. From the audience, in case you have any questions for Ms. Lee, please send to us via the EU IPO ARISE+IPR. The questions from Ms. Lee will be addressed during the Q&A section. Thank you, Ms. Lee. Next, we would like to give the floor for our speakers from Pro IPO.
Good afternoon and good morning, everyone. Okay. Just a brief overview of our office. Okay, we started off as a patent office back in 2012, and in the same year, in October 2012, the Registry of Industrial Design was absorbed. Few months later, in 2013, it was the absorption of the Registry of Trademark. And on the same year is the establishment of IPO office, which was under the purview of a different government agency. And now, since 2019 until present, we are transferred to the AG chambers. Now, this mission is to encourage creativity to foster an IP culture. In order to achieve this mission, these are our vision: to increase an effective IP, promote IP management and commercialization, to improve services, and thus to deliver an efficient IT infrastructure. Now, the legislations governing industrial designs in Brunei Darussalam are as follows: Industrial Designs Order 1999, Industrial Designs Order 2014, Industrial Designs Rule 2000, and Industrial Designs Amendment Rules 2014, and for international registration, Industrial Designs International Registration Rules 2014. The protection for industrial designs in Brunei is up to 15 years. Now, the criteria for registration, the criteria for industrial designs in Brunei are as follows: the design has to be new or novel and has not been registered, published, used, or sold in Brunei Darussalam or elsewhere. There is no restriction on nationality or residency, and ownership by assignment out in writing from the owner and employer-employee relationship or contract for services. Okay. Yeah.
Right. Share and continue from here. We're just going to give you an overview of how industrial
design application process in Brunei. Starting from the lodgement designs form, and then we will assign filing date, usually at 2 weeks after. Within 2 weeks of carrying out examination. After that, where there is no refusal or there is no deficiencies, the office will issue a certificate of registration for the ID application, and moving on to publishing the registered industrial design. Now this slide is showing the filing fees for design, roughly about $800 to $1,000 for single article or set article of industrial design. Now, we would also like to share for joining the Hague Agreement. Of course, one of them is we would like to harmonize the IP system in Brunei with international standards. And as part of our commitment under the Intellectual Property Rights Action Plan 2011-2000, I think this is 2016-2025. And on top of that, we intend to help local designers to gain easier access to enter or expand their presence in international markets. This is a roadmap towards the Hague Agreement, and we have divided we split the whole process into 2 activities. One is the pre-accession, or where consultations and finalizing industrial design regime changes were carried out. And during this period, before we acceded to the Hague system or Hague Agreement, we actually held a national seminar for the SMEs. That was back in 2012. And I think about 1 year, in a period of 1 year, just before we deposited the instrument of ratification, we also did a few of amendments to the legislation. In 2013, December 24th, we acceded to the Geneva Act of the Hague Agreement. And after acceding to the Hague Agreement, we held another seminar, called it WIPO, Post-Accession Seminar on Hague System for SMEs, and that was held in the same month and same year when we acceded to the Hague Agreement. And way forward, up to date, we've been conducting annual stakeholder outreach through IP talks and clinics. And
Where are you?
Excuse me, colleagues from, yes, okay.
Okay, the next slide is we just want to talk and share our challenges acceding to the Hague Agreement. At that time, in fact, until today, Brunei do not conduct a substantive examination, and we think that this might affect the quality of the the registered ID, industrial design. And also, we do not have fundamental amendments in the legislation that reflects best practice. This is one of the bumpy rights, and we think that the trainings on the agreement or accession to the Hague agreement was quite brief, which affects the understanding of the process and operation on the agreement. And now that industry, myself and another colleague, we are now in charge of industrial design. Where prior to this, we were only doing patents, and the other person were doing trademarks. That is still a challenge that we're facing up to date. Now it's we're gonna as the statistic for industrial design application. This is filed nationally. You will see the declining, and I think we can explain the decline, the reason for the decline in 2017 and 17. It was due to the changes, the restructuring in the government, actually, the ministries, where it kind of caused interruption to our activities, especially in carrying out public awareness on filing designs. And in 2019, there was 0 application, again, because of the changes in the office structure. There is a typo error in this slide. At 18, we received a total of 39 applications, and in 2019, 42 applications were received by Hague, and that means that the applications are actually increasing, and this is a good sign of us to the Hague system. BRIP's IP initiatives also include us giving IP consultation, whether it's walk-in or by appointment, and we also provide general advice on IP and guidance on registration process, and we also conducting IP search via online. The website is there, www.ipsearch.bripo.gov.bn. And in our website, we have a search tool under the tab, yeah, and under the IP search, there is design search tools, patents, and trademarks. Straightforward. Just if you go in or search BRIPO IP search, and then you get the option to choose which area that you would like to search for. Okay, this is just how it works. And moving on is the platforms that to promote IP and industrial design is through Instagram. You can also find us at BRIPO on Instagram, and we also have we are also on Facebook, Brunei Darussalam Intellectual Property. And lastly, we are also searchable in Twitter at BRIPO. Okay, I think that is all from us. If you have any questions, would be answer during the Q&A session. Thank you.
Thank you, our colleagues from BRIPO. So now we will move to the Q&A section of the workshop today. We have received quite a number of questions, and I don't know if we had enough of time to address all the questions. In case you still have questions, please send to us. We will try to address all the questions. In case we do not have time, we will address the question during the Q&A session for tomorrow, or we can send the written answers via email after the workshop. So We have received quite a number of questions, and I would like to invite all the speakers of the workshop today to join the Q&A section by turning on your video. So now we will go question by questions. The first question is for Ernesto from our colleagues from IPO Singapore. How long does WIPO take? How long does it take for WIPO to publish notification of refusals, updates on status of design application by a certain designated state on the Hague database after the office informs WIPO? May I invite Ernesto to answer these questions?
Okay, thank you. Well, in fact, this is a difficult question for me to answer because how quick is WIPO processing refusals of protection is not something I'm currently aware. I used to be aware of this very much so when I was in charge of the administration of the Hague system and such. But probably those countries that are, or those offices that are currently refusing protection for international registrations can give a better answer to this. In any case, one thing that has to be taken into account is that notification of refusal may be irregular. There are different types of irregularities regarding a refusal, a notification of refusal. It may be irregular because it just simply lacks the signature of the office or the date in which it was communicated. In that case, WIPO would just simply go ahead and register it in the international register and publish it and included it in the database. But if for whatever reason the refusal for protection does not identify clearly what the international registration is referred to, or for example, if it does not clearly state at least one ground for refusal, it will not be possible for WIPO to register that refusal. So that is why WIPO needs to undertake a short examination to check that the refusal for protection is not irregular. How long does this examination take to WIPO? Well, I would say usually not more than a week or so. So that would probably, if there is no irregularity, in less than a week, it should be possible for that information to be made available.
Okay. Yes. Thank you, Ernesto.
Please.
Yes. The next questions also for Ernesto from our colleagues from PRU-IPO. Is it mandatory for DCP to conduct substantive examination? What is the position for national office who only conduct formative examination?
Mm-hmm. Well, there is no obligation to conduct a substantive examination of international applications. And obviously, if it is an office that does not conduct a substantive examination, but only formalities examination, it would have no work basically to do in the sense that the formalities have already been examined by WIPO. And so the international registration in principle would get approval within the country. There would be no refusal. Obviously, invalidation procedures after registration will always apply according to whatever the national law provides for. Now, it is obviously it is probably better to have some sort of substantive examination undertaken. But that doesn't mean necessarily an examination as to novelty. For example, there are countries that provide for examination as to other grounds other than novelty. For example, that the international registration is not going against public order or morality, or that whether it complies or not with the definition of design. And if it does not comply with the definition of design, it would refuse protection on those grounds. Now, even so, a country may have a system whereby it only conducts substantive examination upon opposition. And this is a system which can be relatively quite convenient for a country. That is, only in the case that a third party, files an opposition, the office would be called to undertake an examination, and it could take into account basically whatever that third party has argued as an argument why there is a ground for refusal. And so the substantive examination would, in that case, only be conducted upon opposition. And you will see this also has an effect or a consequence on the type of fee that would be applicable to a contracting party or country that applies this system. So, again, to summarize, there's no obligation to conduct substantive examination, but your office may wish to do it. Maybe if you have an opposition system, it would not be so difficult to undertake this type of examination.
Okay. Thank you, Ernesto. Next, we receive the questions from Mr. Stefan Hang from ASEAN Secretariat. From the statistic, it shows that the number of direct filings in the EU were not affected by the EU accession to the Hague. In fact, it shows a number of direct filings went up over the years, together with that of the Hague applications. It is a correct interpretation of the statistic?
Yes, I understand the question. Thank you. I believe I have shown it in the last slide of my presentation, showing the overall volume of designs in the European Union, comprehending direct filing of the international registrations. And indeed, the statistic shows that in the last years, the percentage of international registrations proved fairly stable by around 20% of all designs in force for the European Union are international registrations. It remains to be seen whether, as I have mentioned, for instance, the exit from the United Kingdom from the European Union will lead to an increase of this 20% of filings, or also the recent accession of other jurisdictions on a global basis will lead to an increase. But so far, again, in the course of the last 4 or 5 years, the percentage has been stable around 20%, plus minus 1, 2, 3%. So yes, the interpretation as given in the question is correct indeed.
Thank you, Stefan. Next, also one question for Stefan from ASEC. In the event of objection, is there any uniformity of public order or morality in the EU?
Yeah, let me allow to clarify maybe the question, uniformity of public policy or morality in the EU. That probably means that if we have a common standard applicable for the entire European Union. So yes, indeed, there is such a common standard. Public policy being defined usually as all the necessary body of the state of the law necessary for the functioning of the state. Morality being more subjective evaluation of the basic moral norms of the society. So this, let's say, legal definition applies across the European Union. But what can happen, of course, is that between the member states, you may have different standards in respect to certain designs, or typically parts of a design, for instance, the word forming part of the application. So to give you an example, one design was rejected on the ground of a word element which, let's say, glorified the use of marijuana, a drug, in the European Union, which is illegal in most of the member states, but there are a few member states where, under certain rules, the consumption of this drug is allowed. So there may be that there are different standards as far as the basic norms of morality in the European Union is concerned, but it is sufficient for the rejection of a design, be it a direct registered EU design, or be it an international registration designating the EU. It is sufficient if this violation of public policy or morality occurs only in part of the European Union. Just one single member state will be sufficient for that substantive examination ground to apply.
Yes. Thank you, Stefan, for sharing the information. Next, we have questions also for Stefan from our colleagues from Myanmar. I would like to know, statement of acceptance means to grant of design. Is it true? And the second question is, I would like to know whether EU IPO allows to amend the designs violating public morality you mentioned in your presentations as an example.
Well, for the first question, the simple answer is yes. So the statement of acceptance means that the protection is granted for the European Union. And as I explained, this is just communicated by email for the time being with the International Bureau. So yes, the statement of acceptance means that the protection is granted. As to the second question, in general, as far as direct applications are concerned in international registrations, amendments to the design are only allowed if it is still the same design. So it shall not alter the subject matter of protection. So this means, if explained with the example I have given you in my presentation, the bottle design showing the middle finger in between, if this is finally held to be in violation of public policy or morality, it would not be possible to remove that middle finger because it would substantially alter the subject matter of. So an amendment is only possible really if it's minor detail of a design which does not affect the subject matter of protection, which you would consider it still to be the same design. So this will be only the case in exceptional cases where you can uphold your application or your registration in invalidity proceedings by means of removing that part. It is possible in principle, but only under the provider it is still the same design, which will apply only in very rare cases.
Thank you, Stefan. Yes. Next questions from our colleagues from Myanmar for Ernesto. When applicant or holder appoints a representative for filing or other issues, she only needs an appointment of representative form like DM7, or do they need power of attorney also? Yes, we would like to invite Ernesto.
Thank you. Well, there is one element that it is important to distinguish, and is within the Hague system, there is a possibility of of appointing a representative, and this is something that in the application form or in a separate form, a representative can be appointed. But this is a representative for procedures before WIPO. Is it the sound okay? Yeah, okay. So this representative is a representative for procedures before WIPO. Now, the rules regarding the appointment of representatives before a national office, these are governed by the law of the relevant contracting party. And your office, as I mentioned earlier, may require that a representative be appointed once it has issued a refusal of protection, but the representative appointed to undertake procedures in your office or with respect to your office the appointment of that representative will be regulated by your law, and it may be required to have a power of attorney and to be a local representative of the citizens.
Yes, thank you, Ernesto. Now we move to the next question. Question for Stefan from our colleagues in DIP Laos. The applicant fee for international registrations is had to pay direct to WIPO or to EU IPO?
Well, the fees, all of them have to be paid directly with the International Bureau. So the EU IPO does not receive any payments in respects to international registrations directly from the applicant or holder.
Thank you, Stefan. Next is questions for our colleagues from IPO Singapore. The questions from Myanmar. In process of international applications, there are two formality examinations, one by IP and other by IPOS. What are the difference in these two formality examinations? We would like to invite Ms. Lee to answer these questions.
So the checks that IPOS does is pretty minimal. So some checks, for example, whether the design meets our national definition of design, or whether the design meets public order or morality. So for other matters such as whether the representations meet the national requirements, these are not applicable for international designs. And since this, can you hear my reply?
Ms. Lee, is it possible if you have to repeat your answer because it's a little bit breaking up?
Okay, so the checks done by IPOS is pretty minimal. Some examples are whether the design meets the definition of our design in the Singapore Registered Designs Act, and whether the design have issues with public order or morality. Yeah, so that's all. So the other checks are already done by IB.
Yes, okay. We also received one related questions for Ms. Lee from IP Vietnam. Is the Genvisto fee $150 for one design or one application?
It is for per application.
Okay, thanks, Ms. Lee. Next question for Ernesto from our colleagues from Iberfield. Can you further explain the difference between the three levels of standard designation fees?
Yes, sure. We will address this in more detail tomorrow because it has to do with the declarations that can be made by designated contracting party. In short, there are three levels of standard designation fees. Level 1 corresponds to those countries that do not undertake any type of substantive examination. Level 2 is the one that corresponds to contracting parties that undertake substantive examination, but not as to novelty, as to grounds other than novelty. For example, that the grounds that were being mentioned now by Singapore, whether the design corresponds to the definition of design envisaged in the law, or whether it does not go against public order or morality. These are substantive grounds that are not concern novelty, but are other types of substantive grounds. And in such a case, an office that undertakes, carries out this type of examination qualifies for level 2 of examination of designation fees. And finally, the third level of designation fees corresponds to those offices that do undertake novelty examination, some sort of novelty examination. It may be a novelty examination undertaken ex officio, or it may be, as I mentioned earlier, a novelty examination only undertaken in the case of an opposition by a third party. In such cases, level 3, which is a higher level of fees, standard fees would correspond.
Thank you, Ernesto. Yes. We will hear more about these questions in the presentation of Ernesto tomorrow afternoon. Yes. Next is the questions for Ms. Lee from our colleagues from Myanmar. Can we ask Ms. Lee to show the statistic of the number of applicants requests for industrial design registration since accession to the Hague system until now? The applicant numbers were increasing. Is it right? We would like to invite Ms. Lee. We would like to invite Ms. Lee to answer this question.
Okay, so the question was whether we have been receiving increasing number of international applications. So this, I have checked these stats from the Hague database. And as from the stats, yeah, the numbers has been increasing since 2005 gradually. So yeah, that was the question that was asked.
Okay. Thank you, Ms. Lee, for sharing with us the statistic. Yes, we have We have, I think, 2 more questions that I would like to share with everyone. Yes. 1 minute, I will share my screen. Yes. Questions from our colleagues in DIP Cambodia. May I please have 1 question for IPO Singapore and PRO-IPO? Do they use any AI program to help examiner to compare the drawing photo? Thank you. May I invite first PRO-IPO colleagues to start answering these questions?
Okay, thank you, Cambodia, for the question. We have to admit that's a very, very good question. But however, PRO-IPO do not use AI. And yes, as we do not have substantive examiner. Thank you.
Thank you, PRO-IPO. Ms. Lee from IPO Singapore.
So same as PRO-IPO, we do not have AI programs to compare the drawings. And one of the reasons is also because we only conduct formalities examination. So there's no need to compare the novelty of the designs.
Thank you, Ms. Lee. This is the last questions that we received. And this question will be for all the speakers. One of the concerns of the governments as well as the public during their preparation of accession to the Hague system is the loss of revenue from direct filing when joining the Hague agreement. What is your view about that? Are Hague filings going to replace completely direct filings at the national offices? So may I invite Ernesto, if you could have to share your view regarding this concern.
Okay, thank you. I don't think there's going to be any really serious concern. There should be any serious concern concerning loss of revenue. In fact, the Hague system is a source of revenue for the contracting parties because of the existence of this designation fee that we will mention earlier, and tomorrow we will see in more detail. And these designation fees are credited by WIPO into the contracting party's account within 1 month from registration. So each contracting party that has been designated in an international application will receive within 1 month of the registration the amount of the designation fee. And it is likely that, as mentioned by IPOs, that there was going to be an increase in the number of industrial design applications received by the country. Now, whether these are going to replace or not direct filings, Hague applications, no, I would say certainly not, at least not in the short run. There are countries that receive a large number or a large percentage of design applications through Hague. For example, it's the case of Switzerland. More than 80% of design filings in Switzerland arrive through Hague, and only 20% or so by direct filing. But there are other cases, like Stefan was mentioning, the case of the European Union. Hague filings represent only 20% of total filings. I would say for the United States is also the same. In the ASEAN countries currently members of the Hague, I was having a look at that a few days ago, and I saw that, well, in the case of Brunei, yes, a large number are filed through Hague, but in the case of Singapore, it's less than 40% arrive through Hague. The others, the remaining 60% goes directly to Singapore. And in the case of Cambodia, I think we're receiving around 20% through Hague. So I would say it does not replace completely direct filings, certainly not.
Yes. Thank you, Ernesto. Stefan and Ms. Lee and our colleagues from PRU-IPO, would you like to have other views on this? May I invite Stefan?
Sure, yeah, pleasure. Well, I don't know if the experience from the EU-IPO and the European Union as an intergovernmental organization can be transferred to contracting parties, which are countries. But as I have explained, it's 20% of all applications being fairly stable over the years. So to answer the second question, if it's completely replacing it, this is not to be expected as far as the European Union is concerned. As far as the loss of revenue is concerned, I'm afraid I don't have any economical data on this. Of course, the individual designation fees, which is received by the EU, is less than for the total amount of a direct filing, but also the administrative effort is considerably less. As I have explained, we had a single ground of refusal detected so far, and the vast part of the examination process where the examiners have to do their work concerns the formality examination, which is entirely done by the International Bureau. So all this has to be taken into account, and I'm afraid I don't have any economical data. I only know that we have dealing with international applications, we have, well, in terms of numbers, it's 0.1 examiner. So this is half a working day dealing with all the international applications. By rule of thumb, I wouldn't say that the loss of revenue is significant. If any, I couldn't present you with any figures, I'm afraid.
Yes. Okay. Thank you, Stefan. Ms. Lee from IPO Singapore.
For this question, right, I'm just thinking, perhaps we can, for each country, right, we can consider what is the filing behavior of their applicants that are filing with them nationally currently. So if these applicants are only filing at the particular country and they do not have a practice of filing in multiple countries overseas, so perhaps you will not lose these applicants. So, and for Singapore's case, for example, you take a look at our top 5 applicants. So these applicants, they have the behavior of filing through Hague in many countries. So the behavior was that they do not file nationally with Singapore, and with this Hague system, they possibly could just add Singapore as a designated country, and we will earn the revenue. Yeah. So we need to consider whether the filing behaviors of our applicants in the first instance to decide whether we will lose any revenue from direct filings. Yeah.
Yes. Okay. Yes. Thank you, Ms. Lee. Maybe last point from PRU-IPO. Yes.
For Brunei, I think we expect comments from Singapore. Brunei, I think the same. And I think also a way for this is perhaps to do a lot of to carry out a lot of public awareness or promote awareness for the design community, nationally. That's all for Brunei. Right.
Thank you, Brunei, for sharing your point of view. So thank you, colleagues, for all of your questions. We're sorry that we run a little bit late because we received quite a lot of number follow-up questions. We still have more questions, but due to the time limit of the meeting, so all these questions will be answered in our Q&A section of tomorrow afternoon. So we would like to close our meeting here. We have sent to you in the group chat, also in email, the satisfaction survey for the meeting today. So we appreciate very much if you could spend 1 or 2 minutes to finalize the survey so that we can further improve for our future meeting in the upcoming time. So we thank you very much for your very active participation and engagement in the meeting today. As always, we always need more time for our design examiners. So we wish you a very nice evening for colleagues in Southeast Asia and a very nice day ahead for our speakers in Europe and Uruguay. We will see you again tomorrow at the same time. And once again, thank you very much.